used the same power to destroy us and destroy the country. End of quote. I'm quoting verbatim, with intent to provoke breach of peace. So I take judicial notice that the suspect is a sitting and current MP, Member of Parliament representing Naivasha constituency. The suspect was represented by a battery of counsel. They were led by Dr. Kalonzo Musyoka, Senior Counsel, Mr. Muturi, Mr. Kihara, Mr. Kiragu, Mr. Ndego Njiru, Mr. Wairegi, Mr. Malemba, Mr. Nyambu, Mr. Wambugu Wanjohi, Mr. Mageto, et al. They are quite a number. So the state, on the other hand, was represented by Ms. Nora, Mr. Witi JV, Ms. Sonia, and Mr. Momanyi. So in its application, canvassed orally on the 18th day of July 2022, counsel for the suspect have vivaciously opposed the suspect from taking plea. So that is the kernel and quintessence that this court is called upon to make a determination on. Dr. Musyoka, Senior Counsel, has urged that on the casual glance of the charge sheet, the suspect is charged with the offense of offensive conduct contra section 94, subsection 1 of the Penal Code. Senior Counsel adjured that this is purely political persecution and that the alleged utterances falls within the constitutional realm and orbit of freedom of expression and press, and furthermore, the particulars does not disclose any offense. He poignantly supplicated that other people or politicians have said worse statements, thereby imploring selective and or discriminative prosecution. Senior Counsel was appalled by how the arrest was conducted in terms of the public resources used and the numerical force that was used against the backcloth of the misdemeanor charges that now the accused has been arraigned. And therefore he espoused that the acts by the enforcement agency were all unconstitutional. On his part, Mr. Kihara beseeched that the particulars of the offense as well do not disclose the ingredients and were unconstitutional. He submitted that being a member of parliament, the suspect was a mouthpiece of her constituents and which she exercised by dint of Article 33 of the Constitution. Mr. Ndego Njiru guarded this court on the enforceability of rights within the refraction of the constitutional imperative and the dictum vis-a-vis the statutory provisions and the doctrine of stare decisis. He entreated that pursuant to Section 8.1 of the Magistrates Court Act, this court is clothed with the jurisdiction to hear and determine applications for redress of a denial, violation, or infringement of, or threat to, a right or fundamental freedom in the Bill of Rights. He thus urged the court to invoke Article 33 of the Constitution in delineating whether the charge sheet borders on a threat to a right or violation of fundamental principles. Further, Learned Counsel Mr. Njiru, our most stringent argument is that the statutory provisions must be symmetrical and harmonious with the Constitution by dint of Section 7 of the 6th Schedule and Article 10 of the Constitution on national values and principle of governance. He thus avowed that this court has the jurisdiction in entertaining the instant application relating to the threat, the denial or violation of the suspect rights in the contextual milieu of Article 33 of the Constitution on the freedom of expression as juxtaposed with the Section 94.1 of the Penal Code. He buttressed further that the particulars do not disclose an offense for the suspect to comprehend to the charges she is facing. Counsel further argued on the limitation of rights and fundamental freedoms under Article 24 of the Constitution, submitting that rights or fundamental freedom cannot be limited only to the extent that the limitation is reasonable, justifiable in an open, democratic, and civilized society. Counsel basically urging that the three ingredients to the offense has not been disclosed sufficiently, concomitantly offending Article 52B of the Constitution. The Learned Counsel not warranted since no clear offensive conduct had been identified, with the charge sheet being broad, vague, and ambiguous. He adjured that Section 94 of the Penal Code criminalizes conduct Conversely, on behalf of the state, Mr. Whitty vehemently opposed and balked the application. He citing the old aphorism that a court of law down its tools in respect to or matter before it. He reverberated the old aphorism that a court of law down its tools in respect of the matter before it the moment it holds the opinion that is without jurisdiction. On the jurisdictional question of Section 881 of the Magistrates Court Act, Learned Counsel argued that under Section 828 subsection 2 of the said Act, this court's jurisdiction is stemmed and hamstrung to rights under Article 25A and B of the Constitution. Corollary, excluding Article 10, 19, 20, 27, and 33 of the Constitution. He further argued that Section 94(1) of the Penal Code is in force and applicable in collocation to Section 7 of the 6th Schedule of the Constitution. He exhorted that, pursuant to Article 2, Sub-Article 2 of the Constitution, this court has no powers to legislate. Learned Counsel further, Mr. Whitty, submitted that the relevant law governing the framing of charge sheets are found under Section 89, 134, 135, 136, and 137 of the Criminal Procedure Code. He argued that the charge sheet presented encapsulated the statement of the offense and the particulars sufficient to be understood by the suspect. He enjoined that at this stage there is no need to prove any ingredients, each of the ingredients, since the court will be falling into a danger of conducting a mini trial. He beseeched that the ingredients ought to be established during the main trial. So he relied on two authorities, the Kuldeep Madan, Masharia versus KCB and others, 2012 EKLR, which the court held, and I quote, by the Constitution or other written law, it cannot arrogate to itself jurisdiction exceeding that which is conferred upon it by law, through judicial craft or innovation, end of quote. I'll also cite the famous case of owners of motor vessel 1989 EKLR, where I'm sure all of us are familiar with this authority. So I'll note, stated by both parties, the jurisdiction of the magistrate court in dealing with the enforcement of the Bill of Rights has since been addressed by Section 8 of the Magistrates Court Act. The parameters, despite being pellucid, stated under Section 8, subsection 2 of the Act, has also found fortification in the Supreme Court a decision of Hussein Khalid, which I've quoted before, herein above, where the apex court, whose decision is binding before this court, enunciated thus, and I quote, Parliament has granted to the magistrate courts powers to consider applications on alleged violation of the Bill of Rights, but has limited the power to only two rights under Article 25A and B. And that, according to the apex court, is that one is for the freedom from torture and cruel, inhuman or degrading treatment or punishment, and also the freedom from slavery or servitude. I proceed to quote the apex court. This limitation is constitutional, as Parliament does not bar a person from bringing a case alleging violation of his right, but only limits the forum where that cause can be done. They have cited this was captured by the High Court of Australia. I will not go into those. You can have it once you have this ruling. So I'll share with you so you'll have a look at it. So flowing from the foregoing, it is crystal clear and need not be belabored further that this court can only enforce rights that fall within Article 25A and 25 subsection B, paragraph B, of the Constitution. Therefore, on the elemental question of jurisdiction, I will down my tool. So I go to the second question for determination, and that is of the competence of the charge sheet. So the first port of call is on the mandate of the DPP. The office of the DPP is an independent constitutional office which is not subject to the control, direction, and influence of any other person. Under Article 157, Sub-Article 10, and Section 6 of the Act, the DPP shall not require the consent of any person or authority for the commencement of criminal proceedings, and in the exercise of his powers or function shall only be under the direction or control, or shall not be under the direction or control of any other person or authority. The independence of that office is, however, not absolute. Article 157, sub-article 11 requires that the holder of such office to have regard to public interest, the interests of the administration of justice, and the need to prevent and avoid abuse of the legal process in exercising the powers conferred by the Constitution and the Act. So based on the foregoing, it follows that the DPP can present charges within the confines of the law. The question for settlement now is whether, and which is paramount, is whether the charge sheet against the suspect is competent. So there are plethora of authorities on question of the competence of framing of charge sheet. So I'll not go into that. I'll go into section 134 of the Criminal Procedure Code that states, and I quote, "Every charge or information shall contain and shall be sufficient if it contains a statement of the specific offense or offenses with which the accused person is charged, together with such particulars as may be necessary for giving reasonable information as to the nature of the offense charged." End of quote. I'm not going to this, section 176. I've elaborated the provision of that section 137. So, in the often cited case in the realm of framing of charges, the case of Sigilani versus Republic 2004, 2 KLR 480, I'll not cite that. What the court stated. So further, the Court of Appeal in Nyamai Musyoka versus Republic 2014 also expressed itself on the test for whether a charge sheet is fatally defective or incompetent. I'll not cite it. So indubitably, therefore, a charge must therefore be clear and easy to understand. In as far as possible, the use of technical language in a charge sheet ought to be avoided. An accused person must be accorded an opportunity to understand what he or she is facing before court. I've cited the authority of Benson Hatwenge Wafula versus DPP, that is petition number E045. So I'll go to the finality of the finding of the court. So in Doniment, I find that the requirements of a properly drafted charge sheet has been surmounted by the state. I find also on the face of the charge sheet, I'm of the conscientious view that the suspect will be able to fathom and adequately discern and be able to prepare for her defense. So the finding of this court is that I'll direct the suspect to take plea in respect to the charge sheet that has been presented before court.